today's competitive age, to build a unique identity of your brand, it is essential to register and obtain a trademark. A trademark is a name, symbol, logo, phrase or a word which is used by a company, an individual or any business organization to distinctively identify the goods and service of brand and distinguish it from its competitors. Section 2, subclause 1 ZB of the Trademark Act 1999 defines a trademark as a mark capable of being represented graphically and which is capable of distinguishing the goods or service of one person from those of other and may include shape of goods, their packaging and a combination of colors. So, now after considering what is the trademark and how we can protect under Trademark Act, now concentrate on trademark infringement process or trademark infringement issues. The trademarks are protected under the Trademark Act 1999. It provides for the provision dealing with protection, registration and penalties for infringement regarding the trademarks in India. Section 29 of the Trademarks Act 1999 deals with trademark infringement. It defines it as a registered trademark infringed by a person who, not being in registered proprietor or a person using by way of permitted use, uses in the course of trade a mark which is identical with or deceptively similar to the trademark in relation to goods or services in respect of which the trademark is registered. For instance, Rita sells cosmetic products under the registered trademark Lotus. Meeta also sells cosmetic products using trademark Lettuce. Geeta buy cosmetic under the trademark Lettuce owing to the striking resemblance in both the trademarks. It may be said that Geeta has been duped as a Lettuce has deceptively used similar mark for the same goods and has infringed Lotus trademark. Now understand what are the aspects of infringement. Infringement occurs in few cases such as when an infringer takes the essential features of the mark or takes the whole of the mark and makes a few addition or alterations. When the infringer uses such a mark in the regular course of businesses, when the infringer prints the infringing mark in advertisements, etc. Thus, trademark infringement is a basically violation of exclusive rights of the registered owner with regard to its mark. Now, consider what are the different aspects which is coming under trademark infringement. There are two different types of trademark infringement. One is a direct infringement. Under section 29 of the Act defines direct infringement. Direct infringement is a kind of infringement which is a prima facie applicable wherein an unauthorized person violates the exclusive statutory rights of a registered trademark. The constituent elements of direct infringement of trademark which includes unauthorized person, a person who is not the owner or the license of the registered trademark, identical or deceptively similar. The test for determining whether marks are identical or not is by determining whether there is a chance for a likelihood of confusion among the public. If the consumer are likely to get confused between two marks, then there is an infringement. Registered trademark only be registered trademarks can be infringed. Goods or service. In order to establish infringement, even the goods or services of the infringer must be identical with or similar to the good that the registered trademark represents. Now consider the second aspect, indirect infringement. Indirect infringement is a common law principle which not only holds principal infringer liable, but also the person who encourages or assists the infringer for the infringement. As such, there are no specific provisions related to indirect infringement. However, it can be categorized into two. Vicarious liability under section 114 of the Trademark Act 1999 talks about vicarious liability. This section holds the company liable as a whole. This implies that if a company commits an offence under this act, then not only the principal infringer but every person responsible for the company will be liable for indirect infringement, except for a person who acted in a good faith and without knowledge of the infringement. Now consider what are the essential elements for vicarious liability. When the person is controlling the activities of the principal infringer, when the person had a knowledge about the infringement and still contributed to such infringement, when the person is deriving financial benefits from the infringement. Now consider the second and important aspects of infringement, which is a contributory infringement. Contributory infringement is when a person induces the principal infringer to commit infringement, materially contributes to the direct infringement and has a knowledge of the infringement. Now consider what can be the remedies for this trademark infringement. Yes, there are few remedies are available for trademark infringement, and that are, in case of a trademark infringement, the plaintiff has the two types of remedy and has the option to initiate any one or both of the proceeding against the defendant. One is a civil remedy. Damages. The plaintiff can claim damages in the form of compensation. It shall be awarded to the owner of the registered trademark. The amount of damages awarded must be such that it puts the plaintiff in the same position as he would have been if he had not encountered the wrong. Account of profits. This is very important aspects. The plaintiff is entitled to account of profits derived and gained from the misuse of the product or services of infringed trademark. Injunction. An injunction is an order of the court prohibiting someone from doing some specific act. Generally, there are two types of injunction orders, and that are permanent injunction and second, temporary or interlocutory injunction. The court may pass injunction order which will limit the use of infringing trademark. The court can pass interlocutory injunction to discover documents, restraining the defendant from the placing any assets that can cause a severe effect on the plaintiff and preserve infringing products and services. Cost of proceeding. The court can order the defendant to bear the proceeding cost of the plaintiff. Criminal remedy. With an imprisonment for a period which should be less than 6 months and can be extended to 3 years. With fine which should not be less than 50,000 rupees and which can be extended to 2 lakh rupees. So now consider what does not constitute trademark infringement. Under section 30 of the Trademark Act 1999 stipulates certain condition when it is considered that there is a no infringement of trademark, this can be used as a defense by the infringer. When any person is making use of the registered trademark in accordance with the honest practice in a commercial or industrial matters, when the use of registered trademark is not in a pursuit of taking any undue advantage or prove the use to be detrimental to the distinctive character or reputation of the trademark, when the registered trademark is used to indicate the quality, kind, intended purpose, geographical origin, value, time of production or any other characteristics of services and products. When the use of trademark is identical or similar to each other, when the use of trademark is in relation to accessories and parts. When the use of trademark is in the continuance of the permission from the original owner of the registered trademark who has not removed the consent, in such cases the user cannot be said as the infringement of trademark. When the use of trademark is under the ambit of limitations and condition prescribed when the original registered trademark was registered with the registry, then such use cannot be considered as an infringement of trademark. In this session, we learned the importance of trademark registration, and we have also gone through what are the important aspects which can be protect our trademark. While considering the trademark infringement activity, we can prevent it with 3 legal remedies, and also we can protect our brand from infringement. Illegal use of registered trademarks by an unauthorized persons amounts to trademark infringement. Hence, trademark registration for the goods and service becomes necessary to protect the brand and its range of the products. Thank you.